All right, well, hello everyone and good morning. Welcome to Will Work for Food, the New Possibilities Hour. It's November 3rd, 2022. Hard to believe that winter will be upon us shortly. It's so great to be here today. We have a special guest this week, Mr. Bob Berlin, the founder of the New Decision Management Associates, and his topic that he will present on is one that's a lot interesting. Med-Arb, by the same neutral. So if someone is going to be the arbitrator and the mediator for the same case, that's always very interesting to see how that might work out. But before we get going, the favorite part of the day here for so many of us is getting the numbers from Natalie as to where we stand with donations people have made to food banks in honor of Will Work for Food speakers over time. As you know, there is no charge for these programs. And we just ask that you make a donation to either the food bank suggested by the speaker or the food bank of your choice. And then if you'd be so kind as to let one of us know, we'll add it to our running total. Natalie, you're handling that today?
I sure can, Jean. And in fact, it's my great pleasure. The amount today is $328,987.35. Thank you all so much for your incredible generosity. This is more than 3 million meals provided by the resolution industry worldwide.
Wow.
That is so fantastic. And I just love that it's the global legal community doing this, $1 at a time. So thank you all so much. And everyone who's watching this video, thank you as well. And if you can make a donation after watching it and reach out to us and let one of us know the amount, no matter how small, that would be fantastic. Thank you so much. All right, well then let's get to today. First, Mr. Bob Berlin, who's our presenter. He is a mediator, negotiator, ADR professional, and he has experience handling ADR cases in excess of 3,000 civil and family law mediations since 1968. So that's quite a run, and it's wonderful to have you here. I know that you teach and you train, you mediate, you arbitrate, and are a man of many talents and many skills. So it's so great to have you here with us today. Your food bank, I believe, is was a Georgia food bank. Let's see. What is the name? Oh, Middle Georgia Food Bank. Yes. So Natalie will put the link to that in the chat. And then why don't you tell us, if you would, Mr. Berlin, a little bit about the Middle Georgia Community Food Bank. And then the floor is yours to tell us all about Med-Arb by the same person. Thank you so much.
Thank you, Jean. I appreciate the opportunity and a little bit about the Middle Georgia Food Bank. We service about 30 counties. Georgia is the largest state east of the Mississippi, and we have 159 counties. And we're approximately 16 miles from the exact center of the state. So when we say Middle Georgia, we are pinpointed in the state as to almost the exact center. And as I said, we service about 27 total counties. So that's what we do, how we do it, and it's been very robust. It has grown significantly, as has our population. So with that being said, is there anything further, Jean, that you feel might be of interest regarding the food bank?
No, that's great. Thank you so much.
Well, you're certainly welcome, and they certainly would be very pleased to have whatever donations can come their way, because they do a wonderful service to our area. And quite frankly, we've never, from what they've told me, they've never had a shortage that has affected anybody adversely. So at this point, should I be starting?
Yes, the floor is yours. Let's talk Med-Arb.
All right. Well, let me first of all welcome everybody, and let me also say that there are pros and cons to everything. And of course, I look at this panel as having what is known as swarm intelligence. The only person that looks familiar to me is Mr. Hornberger. I don't just has that judicious face about him, and it looks like I have seen him previously. Of course, if anybody has any comments or any questions, please, and I invite you very strongly to make yourself part of whatever discussion can occur. I do ask that if you all can give me some idea as to the read of the room, how many of you are attorneys? And what we usually do is show, this is what they call a jazzy on a virtual platform. And then how many are mediators? All right. Well, please be open to whatever is being said by anybody and everybody. As Nietzsche said, there's your way, there's my way, the way does not exist. So much of what I'd like to put down, and I do plead with you, be part of a conversation with all of us and each other, is that there are many ways to look at something. There are many ways to resolve a conflict. And I know probably many of you have never heard of this, but we even flip coins in mediation. You know, whoever gets wins heads or tails, or we use a deck of cards, the highest or lowest pick, etc. So we use some very unique ways of resolving matters. And especially for the lawyers, we do ask you, just for the sake of the hour, and this really applies to mediation, whenever you're thinking about using mediation to address this, is that what mediation looks for, and I want to use that as a backdrop, if I may, even though this is a hybrid we're going to be talking about, is that we change our paradigm from who is right to what's right, which many times is different from who is right. And a couple of things I'd like to put on the table immediately that might be of help. Many people have a very difficult time listening to somebody give an opening statement or having a discussion, whether it's in caucus or joint sessions, and their mind goes in many places. Lawyers, by research, within 7 seconds of a client starting to tell their story, is already working on a resolution or a strategy on how to deal with the matter. One of the things I'd like to share with you, because I am an ADHD coach, is it's called rapid repeat. And that is, I will speak as clearly and distinctly as possible and repeat every single word that somebody is telling you as they're telling it to you. Initially, your comprehension of what they're saying will take a dip, but it'll get back to whatever they're saying you'll remember. It took me about 30 days to do that, but that keeps me focused on the one who's commenting, which I think is wonderful. At least that's been my experience. So 2 things I'd like for you to keep in mind. One is, and this is for anything you do, is pay attention to what you're paying attention to. Pay attention to what you're paying attention to. And then secondly, and these are gifts you give the parties and yourselves. The second is being present in the present with your presence. Being present in the present with your presence. So those are a couple of things I'd just like to put this on the table. And one of the hybrids we're talking about, and by the way, everybody thinks ADR, because what we're going to be talking about is one of the processes. And Professor Sander at Harvard Law School said, do we fit the form to the fuss, or do we fit the fuss to the form? And many people would say, if I asked, what does ADR stand for, would somebody just offer an answer? Anybody want, what does ADR stand for?
Alternative dispute resolution.
Thank you, Bob. Appreciate it. If I may call you Bob.
Please.
All right. The original A was not alternative. The original A was appropriate dispute resolution processes. The reason they changed it was to bring the legal community on board. Australia has returned to appropriate dispute resolution, appropriate ADR, appropriate dispute processes, which is really much more clearer because that's what we're offering. And also keep in mind, and I got this from the ABA Foundation, and that is only 30% of all conflict is in the lawyer's hands or the courtroom. 70% is not. But many of us who have practiced law, been on the bench, et cetera, believe that we have all the conflict because we live in that environment 24/7. And for some of us, well into a half or more century of a century. So that's what we believe and we think, which is perfectly normal. But one of the hybrids that I'd like to address with you all today is Med-Arb, and that is mediating. And then if it doesn't resolve, switching hats and become an arbitrator, make an award. Now, there are many different arbitrations, high lows, silver bullet mediations. There are a number of different kinds of ARBs, but we're going to just speak generally of the one that issues an award, and let's make the assumption it's binding. And by the way, let me say this before I go any further. How many of you would like to make more money being a neutral? Okay, thank you, Bob. Well, here I'm going to give it to you. And I'll tell you, as a lawyer, the ABA says we shouldn't be handling more than 60 cases, but I handled approximately 300 at one time for a long period of time. But one of the ways you can make a killing, and Bob, you're an attorney, right? Okay, how many, and I'm not asking for personal information, but roughly, would you say about 5 to 10% of your cases after you took them went south, either the law changed, witnesses disappeared, you found out that what your client told you was not easily provable evidentiarily?
At least 10, unfortunately.
All right. And would you say on the other side, they believe the same thing as you did, not for your side, but for theirs?
Yes.
All right. And this is one way that is wonderful. I would go to a lawyer, take them to lunch, and I'd say, how many cases? And I'd go through what we just went through. I said, well, what if I can get rid of 2 of them in a day, legitimately, where you don't get in trouble with the bar? And of course, everybody jumped at it. I know that I would have paid any amount of money to get rid of some of mine. I really did. I just wish they would have disappeared, but I wasn't about to commit any ethical or other kind of violation. And they said, well, how can you do that? I said, well, why don't we schedule 2 mediations a day, one at 8 or 9 and the other at 1 or 2. And then if it doesn't resolve within 3 hours, then I will switch hats and become an arbitrator. And of course, I explained the whole thing, and they said, oh my God, I'd love that. And of course, they had to sell that to their client, which in fact they did. And they knew that that matter was over. I mean, those 2 cases that day were done, and charging $500 to $750 a piece each side. You can make, anywhere from $3,000 to $5,000 or more dollars just that day. And it was wonderful. So there is a tremendous value in that. Of course, one of the things that everybody mentions, most everybody, when they hear that, well, what do you do what you learn in confidence in the caucuses? Well, the first thing we do is we meet with them when they choose to use that process. And most of the time, it's after you're mediating. We do mention it beforehand, but they'll say, oh, my God, we settled almost everything. And lawyers will say, if we don't settle everything, we don't settle anything. So you're always stuck with that attempt at leverage in negotiating. So anyway, I would meet with the parties and I would ask them, what did you say in caucus that was not discoverable that you wish for me not to consider? And 1 or 2 of the ones many that I did would say something, but it was rare. They said, well, there were some, yes. So I respected that. Of course, some people say, well, Bob, how can you ignore the pink polka dotted elephant that they mentioned. Well, it's hard to do sometimes. It's a challenge. When I sat on the bench, admittedly, there were some people I just did not like the way they treated other people. And I wasn't concerned about the word neutral. I was concerned about the word balance, because many times the way people, and I've noticed this in mediation, many times the way they treat other people is just horrible, and it just breaks my heart. Can I be balanced? Because I certainly wasn't neutral, but could I be balanced in the way I dealt with things? And if I could not, and there were a couple of cases I could not, I recused myself and did not charge them for whatever time we had used, because I didn't feel it would be right to abandon them. I didn't see it as abandonment, but they might, and then charge them for it. So I didn't do that. So basically, that process worked very well, and it's a way that matters can get resolved, especially when you have, and I know in California in some domestic cases, that you have some mediators have multiple meetings. The first one being having contracts signed, opening statements given by the parties, and then assigning different sessions to deal with the different issues that had to be dealt with. Other states, especially Georgia, they want everything done in one day. You know, I went 26 hours in one and 16 in another. I mean, that's what folks here in Georgia like to do, get it done. And they don't like it. Plus, there's a value in that too, because the emotional arms after some period of time will come down, and you'll hear from the lawyer or the party, do you really want to know what I want? And then they'll come out with it. So there's a lot of benefit. Time is an ally in those instances. So let me ask, are there any questions or comments? And please feel free, because we all learn from one another. Nothing. Wow. Well, okay,
We're
Bob.
on every word. We're just
Have you
hanging.
done any, what I know are referred to as baseball arbitrations?
Absolutely. And for those of you who may not be familiar with baseball arbitrations, it did originate in baseball, where both parties came in with a figure, and the arbitrator was given a choice between picking one or the other. And is that basically what you're talking about, Bob? Then you have night baseball, which is a baseball arbitration, which is a little abbreviated. It gives the mediator, or the arbitrator, gives the arbitrator a little bit of wiggle room that he or she can go up or below a certain percentage. So not only do they use the figures of the parties, but they're given the authority to move a little bit up or down on either or both figures. So we've used the baseball arbitration a number of times. And quite frankly, it's very encouraging to the parties to pick figures that they think would be reasonable, so that the arbitrator can make a reasonable a choice between two reasonable figures. And sometimes when they're not, you have a tendency to go with the one that is. So, and you mentioned, we mentioned to this up front with the parties so that they know what choices they're making. And of course, we say, are there any questions? I did one 20 miles from here in Macon, where my partner and I have our office, in Warner Robins, which is one of the two largest Air Force base maintenance bases in the nation. The parties went through an 8 to 10 hour divorce mediation. They settled everything, and there was high profile individuals that were connected politically, and they didn't want anything to go to the courtroom. And we had mediated everything but the resolution of the division of the personal property. And he wanted what usually went to the female, and she wanted what usually went to the male. Like she wanted the fishing boat, the rifles, the hunting rifle, etc. And he wanted the silverware and the flatware and dishes and so forth. Anyway, and I said, well, why don't you get an arbitrator? And they said, well, if we're going to do that, we can just go to the judge and that won't cost us anything additional. I said, well, why don't you then go to the judge and do it by letter? Well, hell, if we're going to do that, we'll just do everything in front of the judge. You know, if we don't settle them all, we don't settle anything. And I said, well, why don't you use me? I said, well, can you do that? I said, well, yes, if you will allow me. And I went over the process. We swear everybody in and how the testimony is proffered and rules of evidence are relaxed and so forth. And they said, that's great. I said, all right, I'll listen to your evidence. And of course, some of it was very short form because I asked when you discussed that in the mediation under oath now, are you willing to agree that that was true and correct when you discussed it? And some would ask me for a caucus, and the other lawyers were okay with it. And so we dealt with that issue. But in every one of them, they said, let's go forward. And we did the arbitration. And then I told them, even though our law says you got 30 days, I said, when I leave here, I'll get an award to you within 10 days. So it all worked out well. Other questions? No other questions. All right. Well, one of the ways that, and what I mentioned earlier about how you can really help the legal profession, help the parties mainly by getting resolution, because it's a wonderful process. You have it there, it's available. We had where the parties, a judge and her husband, who was also a lawyer, wanted to deal with the custody, and they agreed for the court to enter an order ordering them to do it, a consent order, ordering them to do the Med-Arb. And the judge who was handling their divorce was just thrilled about it. And periodically throughout the entire mediation, both the parents would say periodically, I don't want Bob making this decision. And quite frankly, Bob didn't want to make the decision either, because most of them, even though I've been a judge and arbitrated numerous cases, and most folks they don't want to make decisions. It's very difficult. I mean, you make them every day, you make hundreds of them a day, but you really don't like to. And for your information, Harvard came up with what they call their iron laws. There are 10 things such as people choose not to make a decision. We make decision based upon inadequate information. We always have buyer's remorse, etc. So if you can get a hold of those, that's fine. If you have any difficulty, I'm guessing Natalie or Jean, I'll be glad to send a copy to you all so you then can disseminate it to those who would like to have it. And Harvard I was trained at Harvard, and they gave us permission to share it. So I'm not violating any proprietary rights of Harvard or otherwise. So the process is very clear, and you make sure it's clear. We do anyway. We'll mention it up front. You can always, if you don't reach a resolution, you can let us know about it. And we'll know about it. And you can, if you choose, then you can ask us to make a decision for you as an arbitrator. And of course, can you do that? Well, if you both agree, you can do it. And a few have done it up front, but not many. And then when they placed all of that energy in during the day into mediating, and then reach that one issue, they said yes. So it was extremely beneficial for the parties to have that as an option when we brought it up later, because quite frankly, as I said earlier, when time is your ally, they don't want to leave with nothing. It's just like an insurance company sending an adjuster mediation. They spent all day, and when the adjuster returns, the supervisor said, well, did you get a resolution? Well, no, we had impasse. You had impasse. You were there all day. So there's a desire for matters to be resolved in most cases. Every once in a while, you won't find that to be the case. People will come and they'll give you codes like, I'm here to negotiate in good faith. And of course, if they say that 5, 10 times, what they're really saying is, I'm not here to negotiate in good faith. Just like somebody, as an example, will say, with all due respect, none is coming. I mean, it means no respect is coming at all. So these are the kinds of words. And let me give you another word that we use regularly in our training, that if somebody says, this is how far I'm going to go, and that's it, I'm not moving at all any further. And many mediators get quite nervous about it and said, oh my God, we're at impasse. But let me give you one word you can use that will work, and you say it to yourself. And that word is now, N-O-W, because right now they're not going any further, and that's okay. And of course, keep in mind that, let me ask just a broad question of everybody. When do you first know that the parties are at impasse? Not all at once. I'm having trouble on the board figuring out who you are. Jean, do you have any idea? What are your thoughts about it?
My goodness. Well, certainly if they're both being very firm and saying they're not moving, but I don't really think that. Maybe more when they get emotional about it, or definitive anger comes out or something like that. I mean, it all depends on the case and the people.
Well, thank you. Let me see if there's anybody else that would like to proffer an idea about it.
So respectfully, I'm from India and I do family mediations, and I quite often see impasses, and it happens mostly when they start repeating past instances. They do not keep going back to their positions. So I feel that time it is an impasse.
Well, Sonal and Jean, I'm sorry.
Yes.
Were you finished, Sonal?
Yes, sir. Thank
All
you.
right. Well, let me share with you another view, because I think you're both accurate. But when they walk in that door, they're at impasse. Or why would they be there? I mean, do you see so much of this is so logical? I mean, when they say, right now, I'm not going any, when they're saying I'm not going any further, it means right now they're not. And we just say, okay. And then we use a concept that is just wonderful. It's called yes and. How many of you use it in mediation? Yes and, for those of you who are not familiar with it, came out of improv comedy. And yes means I hear what you're saying and tell me more. And you keep your mind off judgments and labels so that you can move forward. And that is, we never reject anything. I mean, I've got a little scar on my thumb that my forefinger that my brother gave me as a kid, and I want $1 million for it. And I know statute of limitations, order of proof. I mean, there's no way under the sun. But if you tell me I'm not going to get anything, even though I agree with you, I will resist that. So we never resist anything anybody says in mediation. And by the way, when you do a hybrid, and this is, I think, the most wonderful part about it, is you're developing a relationship with the parties when you're mediating. Many mediators do not do that. Let me ask, who's a live person, Jean? I didn't want to jump on you about this. Is there another, I want to ask for a female, if I may, because I have an example. I will promise you I won't embarrass you or anything. I just want to give you some ideas about this. Sonal, All right, I want you to think about that if I told you, and I want your very first feeling about this, if I mentioned to you that you're being followed by 4 older teenage boys, what's your first thought?
Just followed, um, I would get panicked first thing.
All
If
right.
it because I'm in India and yeah, first impression would be panic, but then I logically think about it, that what could be the reason, or I would talk. I mean, if you are saying so, I would talk to you. How do you feel? Why do you feel that? I would be alarmed,
Well,
but
most everybody says that, many say the same as you did. But this, we asked the question, what's truer than the truth? And again, Gene, this is a logical thing. Until I tell you they're following you on Facebook because they like the things you write. And until we know the context, and so many of us, me included, fail to find the context within which things are happening, because the context gives it. What's truer than the truth is the story. So what's the story? And as soon as you heard they followed you on Facebook because they like your writings, how did you feel? Did you feel relief?
yes, it's like normal, and I would feel glad that I talked to you about the whole thing. I mean, just not half of the thing. Yes, that would
Well,
feel good.
because many of us do not do that. I had one mediator because I was, I'm asked to evaluate programs, and one mediator came in. He happened to be a retired judge as well. And as he was seating himself, nobody knew what his name was. I did, but the parties and the lawyer didn't even know who was going to mediate the case. And as the mediator was seating himself, he had not seated himself in the chair. What's the GD problem we got to solve today? And of course, everybody in the room backed up physically from the table. And I sat back because I'm saying, oh, this is going to be very interesting today. And within 10 minutes, it was an impasse, and I had to give him feedback first before I turned in a report to the executive director of the program. And I said, Judge, I said, that was quite an interesting opening. He said, well, that's what we're here to do. He said, maybe I was a little strong. And I almost chuckled thinking, you were strong, you blew them out of the room. But in any event, to me, how many of you think of when you hear real estate, what are the 3 words that people share about real estate?
Location, location, location.
Exactly. Thank you, Bob. And in mediation, and even in arbitration, it's relationship. And if you really spend the time building contacts, finding out who they are and how did they get to know each other, and begin to get a sense of how much they're revealing, not how wrong the other side was and how right they are. But as you build that process, and it takes a while for many, because they don't trust the other side, but for different reasons that they don't trust you. But over time, you build that trust, and you will hear things that you ordinarily would not hear, that at least give you insight as to what may motivate them and what the real agenda might be if it's different from what they've asked for. And oftentimes it is. And I'll give you something you can take to the bank. I've done 106 Med-Arbs where I've acted as both the neutrals, the mediator and the arbitrator. Only four out of 106 went to arbitration. Only 4. And all the others resolved. I know, was it you, Bob, that brought up baseball arbitration? All right, there's another concept known as silver bullet mediation. Has anybody ever heard of that one? Bob, would you share your thoughts about that if you don't mind?
My first experience was as a trial lawyer, but I continue to do it as a mediator, and that is come up with a number between the last ones, not necessarily the midpoint, and usually not the midpoint, and go to each of them. Nobody knows the other ones. It's been proposed. And if they both do it, fine. If they don't know that the other one's done it. At least that's how it's done in my practice.
Okay, well, thank you. I've never heard that before. The definition, another definition is an arbitrator comes in and arbitrates the matter and seals an award and gives it seals it in an envelope and gives it to the mediator. The mediator conducts a mediation, puts the envelope on the table at any time. Either party can grab the envelope. The mediation is over. I've done about 20 of those. Nobody's grabbed the envelope, and I've shredded it once they sign the agreement. So there's another two additional processes, one that Bob just highlighted, and the silver bullet mediation concept as well. Many folks have a question. Well, Bob, and I mentioned this earlier, how can you really maintain your neutrality? How do you deal with confidential information, et cetera? And I'm not saying it's easy, but I think I've done it well enough that some of the same lawyers have used us in doing it, which to me says a lot. But I will share with you what a number have said to me directly. I said, well, I may have heard things in caucuses that might not intentionally be influenced by it, but I might. I don't know. I don't think I will. That you've told me to keep confidential. And then this is what was said a number of times, almost in the exact wording. Bob, you know more about this case than anybody could. And therefore, we really feel that you can make the best decision in this case. And that said so much to me, because many of us, goodwill, good people who want to do the right thing, will say, and I know as a lawyer, and I've been a lawyer over half a century, lawyers will say, I would recommend you do this, that, and the other. And I think they mean well, but most of the attorneys doing that have no clue as to what the parties value. What's their value system? What's important to them? Because, I'm the center of the earth, and anybody who thinks differently from me is wrong or not right. But if you know your client, there are just so many things that the client knows about themselves that can give us some information. Many say, well, Bob, we don't have time to go through all of that. And some will even say, this is not counseling, but it is. The more you know about your client or the parties, if you're a neutral, be it arbitration or mediation, and not as much in the arbitration because it's very similar to a trial. But getting to know the people is so critical, and the fact that you are interested in them, and it's so much less expensive, and it doesn't hose down the parties with the attorneys, and of course, and I know I'm jumping around a little bit, but thank you for letting me do it. Many folks have probably never heard what I'm about to say, and I say this in a mediation. I want you to all look at your lawyers when I say this, because when we get them to rethink the idea, I want to go to court, I'll meet you in court. And of course, what their idea of court is law and order. You can have a criminal case investigated in 18 and a half minutes, and you can have a full trial in 18 and a half minutes. Of course, it takes me 20 minutes to introduce myself to a jury if I cut it short. But in any event, many parties, and they'll look at their attorneys, and of course, the attorneys will think, as they look at me, and they say, well, what are you going to say that I haven't heard before? And while they're looking at the attorneys, and I want everybody here, for those that, how many of you that are on video are attorneys? All right, for those of you who are watching, look at them when I say this. To me, a trial is the only living autopsy from which you walk away. And you see nods and smiles, and the clients are going, oh my God, you know, I've been trained by Law and Order. I didn't know that. And there's a law review article from Wake Forest 2013 that says all parties that are not professional parties or witnesses get PTSD. I mean, all of them get it, and some witnesses and some jurors. So there are so many unique things that can, reality things that we can put on the table that can be very, very helpful in helping them first get to know you. If you're the neutral, get to know the lawyer, you, the lawyer, if you're in your representative capacity, because, you know, it's a partnership with clients, and we're there to, you know, you got fight, flight. What we do as mediators, try to get them to unite. And we do it through a collaborative process and not take up sides. And hopefully, if we can do that, and if any of you have been schooled in the Harvard mutual gains negotiation concept of negotiating, getting them in the options part to collaborate. How can we put something together that you both can contribute to? Because so there have been a number of research is done on mediated agreements, and when parties fully comply, fully invest themselves in the process, and then come up with an agreement that represents common ground, they'll support that to which they give birth. And it is so helpful when I know Carolyn and I were the only committed co-mediators in the state of Georgia. We've done it now for almost 2 decades. And even if it reaches impasse, they give us a hug when they leave. Even if it's an impasse, because they've gained something from the process. It's not a loss. It's, even though they didn't get it. And insurance companies in our southern region, and I imagine they do it all over the nation, I don't know, but for a fact here that if there's a casualty loss and they reach and they go to, of course, if the adjuster goes out and pays the parties, the claimants, it's closed by adjuster. If they go to court and a judgment is rendered and they satisfy the judgment, they put closed by judgment. If it's done by mediation, they'll put closed by mediation if they've reached an agreement. If they have not, and it does resolve in 30 days from the date of the mediation, then it's closed by mediation, because you got parties to talk. So there can be an absolute benefit coming from that. So you can gain a lot. And one of the things that, I don't know of any mediators that do it, but Carolyn and I do it, is if it does reach impasse, meet with them privately. What are you going to do from here? What are you going to do? What's your next step? You remember when Joe said he was very interested in your offer to build that fence? You might want to think about that, because that seemed to be a strong point, a little concern to you, but high concern to him. And by the way, if you all need me in the interim while you're discussing it, we'll consider that a caucus. And if I do have contact from one, I will then contact the other and advise them I've had a caucus with you, and I'm offering a caucus to them in return. And one other thing I'd like to share with you, and that's pre-mediation activity. Since the pandemic started, a little bit after that, Carolyn and I have been doing pre-mediation activity, and every one of the mediations has resolved. Every one of them. For those of you who enjoy reading, Lee J. Berman and he's in California, wrote an article, it's on mediate.com, entitled The Fallacy of Impasse. He thinks whoever came up with the word impasse should be hung. but it's wonderful. It's 11 pages. It is wonderful. And if you, it's a free site for many of us, for all of us. Many of the articles are, and they've got anywhere from 5 to 20 some odd thousand articles. And you can just look up pre-mediation questions they ask, and they're wonderful, wonderful. You get to know them before you even show up for the mediation. They get to know you. You develop a relationship. Many times things that bring you to impasse because they didn't share information. When you get to the mediation itself and you don't have any pre-mediation activity, I mean, I can't tell you how many times we have found that they could have, there's information that one needed from the other in order to make a reasoned decision. And we were able to encourage the party that was a little slow sharing it to share it. And of course, we in our comments, would you like to see this matter resolved? And every once in a while, one will say, hell no. You wonder, well, why are you here? Of course, some of them have been ordered to be here. But anyway, I just thought I'd give you a little bit of additional information that might be of assistance, whether it be a Med-Arb or whatever it might be. Any questions or comments or observations that anybody might have? The article is The Fallacy of Impasse. The Fallacy of Impasse by Lee J. Berman, B-E-R-M-A-N. It's wonderful. And it renews faith in the process. To me, it did. My partner pushes that all the time. Have faith in the process, and she's so right. And it's wonderful. Other thoughts? Yes, it is the fallacy article.
Bob, I don't want to monopolize thing, but the reason I asked about the baseball mediation was my first experience at that was a federal court multi-party construction project where there were only 2 left, and both sides had been to mediation 3 times and they were worn out. So I go with my client, we get to the baseball arbitration, and at dinner the night before, he says, you realize even if the arbitrator picks their number, I've already won. And he meant it. Their number, as you said, they've got to take as little as they can that they can live with. And he said, I don't know who came up with this baseball arbitration idea, you or the other lawyer, but I'm glad. Even if we lose tomorrow, we win. And this is a case that's been going on for 3.5 years. The judge didn't want to try it. And so that to me was the effective thing. The other question you had about excluding things is, to me as a trial lawyer, clients come in and tell us their story, and we have to, in order to evaluate the case, tell them the things that are not going to be admissible, that may be the most emotional thing to them, that pumps up their value of the case one way or the other. And so as the mediator / arbitrator, I think we're doing the same thing. We're having to deliver the bad news to these folks. That may be important to you, but that's not coming in.
Well, thanks a million, Bob, because I think what you said is gold. One of the things that we don't do, and I violated, I don't want to say violated, I'm part of that, is when we talk about what will get in, and I'll ask the lawyers after we've been there for a number of hours, do you think, we've been here for 6.5 hours. We've been here close to over 400 minutes. Do you think your client could get 5% of what he's talked about in the courtroom? And the lawyers regularly will say, if we're lucky. And whenever we talk about what they won't get in evidence, lawyers don't do this, and I beg you to consider this. Let me tell you why there are rules of evidence and why they won't be allowed in. Because if you just say the judge won't let it in, it doesn't mean anything to the parties. It really doesn't. But the reason they have rules of evidence is to make sure that it is relevant, that it is non-cumulative, that it is pertinent to what's going on, and we can rely on that And over the years, the courts and the legislatures have done this to make sure that whatever result comes out is based upon things that can be proven. Because when you go into why they're there, for some, it makes a difference. But if you just say, well, you can't get in up to, you couldn't even get 5% in, and say, oh my God, I've been here for 400 minutes or 6.5 hours, and you're telling me I can't, but only 5% of what I'm saying can get in. And I really think in part of our discussion, whatever the position you have, is to say why. And by the way, in arbitration, I found this to be so helpful, as well as sitting on the bench. And that is when they finish giving you the evidence, and I heard somebody say, boy, that judge didn't listen to a darn thing I said, nothing. So before they left, I said, let me see, Mr. Witness, let me give you a summary of what you just said to me. Did I get it? Did I miss anything? Oh, no, Judge, you got it. And that way, when they leave, they've already told me whatever my ruling might be, I at least in their view heard the evidence. And I do that in the Med-Arb. Let me see if I understand what you said to me in summary. If they've been there a number of hours, I just want to summarize, and I think I'm okay with that. Somebody wrote, was it in the chat? I wanted to, I don't remember who did that. Tim, I'm not sure. We had somebody here many years ago that just mentioned it. I looked up for training purposes, because Carolyn and I, that's one of our main functions, to look at the agenda, but I'll be glad to work something out. I don't know where to even recommend, because I looked up who does it or who trains for it. And even there's a wonderful area, if anybody's interested, end-of-life decision mediations. Hospital pay you $2,500 to $7,500 a day to do that. Nobody, to my knowledge, is doing that. I was trained in that, by the way. But Tim, I'll be glad to talk further and just tell you what could be involved if you'd like to do that. Let's see. Oh, thank you. Thank you so much, Bruce. Thank you. Thank you. Thank you. Thank you. I'm going to make note of that myself. Let's see. ADRIC in Canada. I think I'd like, Carolyn and I could offer that.
So basically that's, for those who are listening, ADRIC in Canada now does Med-Arb training.
Oh, super. Thank you so much, Jean. And yeah.
That's fantastic.
Oh, by the way, the pre-mediation, David, you asked about that. I hope I didn't cut you off, Jean. How does the payment schedule? Because it's new, we are giving the first hour free. And we say that we're not going to charge our regular fee, but after that, our fee kicks in. So that's how we charge it, because we're giving them a service. And it's a really good one, because we're there working as hard as we can to help them find the common ground. And by the way, we never, what Carolyn calls an ism, we never make a direct statement. If you want to say anything to any of the parties or attorneys, may we recommend you put it in the form of a legitimate question. We never tell anybody what to do. Have you considered, would this be of interest to you? We drain them dry before we put anything on the table that we can think of in addition to what they put on. Any other questions or comments? Oh, Lee, wow. Lee, what is this that you've put on? I mean, is that where training can also be accomplished?
No, that long link is to an article from the Michigan Bar Journal on Med-Arb.
Oh, thank you. Thank you so much. Gene, is that possible that we can have the chat, copy of the chat sent to everybody? Because that is long and
Well, I would just suggest that everybody goes ahead and copies it right now for themselves and pastes it, emails it to themselves or whatever. You will, Bob, you will get the copy of the chat and the video.
oh, okay.
I don't believe the chat is included with the video. Natalie, well, I don't think that it is. So, yeah. Okay, we have more questions though in the chat. Are you going to mediate between your Senate candidates in Georgia? Oh my goodness. Someone's getting a little bit bold there, right? Asking that question.
Well, thank you for asking that question. Herschel, I loved him on the field. I really did. And I've been in politics, both elected and appointed. And I also know in mediation that sometimes you have to say, we can't go any further. This does need to be decided by a neutral or a panel jury. It's just like what we say is, it's like teaching a pig to sing. First of all, you're not going to accomplish it. And secondly, it's going to upset the pig. So we've got to really recognize those situations that are not going to settle and acknowledge that. But we do go into every mediation, Carolyn and I, we don't even think of impasse, and we don't call it ever. But we do walk in there thinking this is going to settle. The only question we have is how long is it going to take? Because when you walk in with a mindset, they're going to pick that up. Over time, we put everything in a positive reframe. People will say, we don't even use impasse. We say this matter has reached a point with the yet to be discovered resolution. Like people will say, well, KISS, keep it short, stupid. It's keep it short, sweetheart. I mean, we find as much as we can to reframe it in ways that are positive. And if we maintain that positivity, that positive attitude when we walk in, it's contagious, it spreads. There was a team in a high school football team, Montclair, and they won 100 and some odd games straight, and they walked on the field with the helmets in their hands as if they just lost the game. And they said, no, they were just struggling with how much they were going to beat the other team by. So I think what we bring to the table can be contagious, and that's what we bring.
Yeah, I'm sure everybody here would agree with you. That's for sure. One more quick question, and then we'll be at the top of the hour and have to bring this to a close. But you also mentioned, this is in the chat, you also mentioned an article about people getting PTSD from going to court. I'd love to see that article. Do you remember where that article is?
I'll have to research, but I believe it's the volume 2013 of the Wake Forest Law Review.
That sounds like it's a good start for the research. We can do our own. Thank you so much. Does anybody have one more quick question? We've got 1 minute left.
Let me ask you, Gene, what's a quick question? Is that one you answer real fast?
That is. Sana?
Yeah, I wanted to ask about, he talked about end of life mediation. Does it encompass something in hospice setting? Something that is in.
Well,
Yeah.
I was trained in it, an outfit in Colorado. I have since looked for it. I don't know whether they're out of business, but it was wonderful. And it's an area where hardly there are any mediators. There are none in Georgia. And at one time I was interested, I did too, and they were very financially rewarding. And it paid a very significant, each one paid a significant sum. And it was just wonderful. But anything you pick, let me make one comment on that, Gene, and I'll be done. Anything you pick, if you're okay with spending significant time with the parties demographically, and you like the subject matter, pick what you like. There's a book, do what you love, the money will follow. And that will be, you'll be able to be fine. And you also become an expert in areas if you get to niches in different places. But let me thank everybody, and especially Natalie, thank you so much for allowing me to be part of your program.
Thank you so much. It's been a pleasure. We would ask if everyone would please consider supporting Mr. Berlin's food bank, the Middle Georgia Community Food Bank, and it's at MG, can't read the rest of this here, mgcfb.org. So thank you so much for being here with us today. Thank you, everyone. We'll see you next week. We've got another great program for you next week. Thursday, same time, same place. It will be Sam Ardrey talking about the justice gene and the problem of righteousness. You know, we all think we're right, I guess. So anyway, it promises to be an excellent speech. I heard him speak on this recently, and it was fantastic. Thanks so much. Have a great day. Bye-bye.
Thank you.